much. I'm joined right now by Dr. Ashwani Kumar, former Union Minister and Law Justice of India. Thank you, Dr. Kumar, for joining us this evening. Your quick reactions on the Supreme Court coming down heavy, rejecting the apology of NCERT over the chapter on corruption in judiciary.
Well, I think it's a decisive pushback by the judiciary against what it sees as an attempt to denigrate it and to compromise with the administration of justice. I personally believe that the sweeping and inferential indictment of judiciary in the subchapter that is under challenge in the NCERT curricula is reprehensible and I think needed to be curbed with a strong hand, which the judiciary has now done. I have no doubt that this case would be used by the judiciary, hopefully, to lay down guidelines for the future so that no institution of our constitutional democracy is subject to a sweeping indictment without any empirical evidence whatsoever. I believe that the matter raises a much more fundamental question about the resilience and about the integrity of the institutions of India's libertarian democracy. Supreme Court, or for that matter, any court or any institution, be it parliament or the executive, could be faulted for certain and specific missteps. But a sweeping indictment of any constitutional institution is wholly unacceptable and is a constitutional heresy.
But Dr. Kumar, in a democracy, there are no sacred cows. Why should the judiciary be above questioning? There have been recent cases of corruption that have been very evident. And why shouldn't children learn on that? Why should the judiciary be above question?
Well, there is no doubt that there are aberrations in every institution, as I said in my opening statement, and there are processes to deal with those aberrations. There are processes to deal with those cases, as indeed is being done in several cases. However, the judiciary as an institution is much wider than the specific instances of missteps or wrongdoing. So therefore, to treat or to raise perception founded on certain instances to the level of reality and the ultimate truth is wrong. And what is worse is that children of impressionable age are sought to be told about corruption as if it was a gospel truth. There are instances of wrongdoing, and in every country, in every institution, and they cannot be defended. Of course not. And the judges have suffered flack. They have taken censor, and they have been subjected to scrutiny in various other forms. But to teach in the classrooms of the 8th class that the judiciary as an institution is corrupt inferentially is wholly wrong. Just imagine what happens to the right to reputation and dignity of a vast majority of our judges with impeccable credentials. What happens to them? What about their right? So right of free speech or right of censor is constitutionally subject to certain restrictions. And the Supreme Court would have done well to ensure that there is no whole-scale denigration or tarnishing of the image of the institution. The Chief Justice has taken the right step at the right time in calling those to account who are responsible for such a misstep.
But Dr. Kumar, let me ask you this. The top court has taken suo motu cognizance of this, shown judicial activism, which, if you look back, is subjective. They are the conscience keeper of democracy. But having said that, in the case of NCERT, this is not the first case where entire chapters, there has been stuff which has been contentious. Chapters have been removed earlier, not just on history, on protest. The top court of this country has not been as proactive in those cases as it's been when it came down to its own position and the question on its own institutionality.
Well, better late than never. I wouldn't have minded if they had been active earlier as well. But there always comes a tipping point. And I think if this is a tipping point for the judiciary, so be it. And hopefully the activism of the court will not be limited only when it comes to questions about corruption and judiciary. They would be as active in correcting aberrations in other institutions. I have no problem with that proposition. But two wrongs don't make a right. Or let's say if there's been some latitude in other cases, doesn't mean that you continue to keep giving a latitude. So therefore, I think at some point of time you have to take a call. But this was, I'll tell you, this is a standalone case in the sense that nowhere, at least to my knowledge, has in any constitutional democracy a chapter been added in the school curricula to say that a particular institution, which is a vital pillar of democracy in that country, as indeed it is in ours, is corrupt as an institution, as a whole. I think this is the only example of its kind, if my memory doesn't fail me. Therefore, extreme cases require urgent measures, and the Supreme Court, I'm glad, has risen to the occasion. And I'm sure that this would become a precedent for the Supreme Court to check similar insidious propaganda against other institutions and in other places as well. There has to be some empirical basis in the discovery of truth. That is the fundamental principle of judicial adjudication. There has to be some factual basis for this. Now, just because 4, 5, 8, 10 out of thousands of judges have been found prima facie guilty of some wrongdoing, does not mean that you have the right to tarnish the institution as a whole. That's the issue. That's the point of principle I'm trying to make. Nothing more, nothing less.
Okay, fair point. Dr. Kumar, thank you for joining us this evening.